Thank you for joining me. We're going to talk a little bit about estate planning today, with the big question of the hour being, do I need a will or a trust in Arizona? And we'll try to do our best to see if we can help you answer that for yourself as we think through the elements of estate planning here in Arizona. Um, Question is something that we want to try to answer. But before we get started, I real quickly want to just make sure I introduce myself. My name's Emily Taylor. I'm an attorney here in the state of Arizona. I grew up in the Midwest, but came here to go to school. And so I went to both ASU and U of A. I'm a proud member of the State Bar, of course, but also the Special Needs Alliance, as well as the National Academy of Elder Law Attorneys, and some other great organizations. And so, with that, I will offer that we provide services in the state of Arizona. I'm only allowed to give legal advice in the state of Arizona, but in fact, this webinar that you might be watching live or recorded is not legal advice to you. And so, the disclaimer is please be sure to work with a professional that you have a relationship with. And this does not create a relationship. I hope you learn some things, but encourage you to find an attorney to work with for your personal situation. And with that, we're going to dive right in. So back to the question of the hour, do I need a will or a trust in Arizona? The reality is you need a plan. And it may not be a one size fits all will or trust, but what we're going to do today is learn about some of these different elements and make sure that you have the right plan in place to accomplish your goals, because everybody's got different goals and different things that they're concerned about and hoping to accomplish. But generally, when we think about estate planning, we are thinking about a whole bunch of different elements that might help us fix our problems. They might help us prevent problems. But today we're going to talk about healthcare directives. We're going to talk about wills. We're going to talk about trusts. We're going to talk about financial powers of attorney, beneficiaries, a whole bunch of different things. And hopefully we'll understand at the conclusion of our presentation today what these tools might do for you. And when you've got a good sense of what your goals are, which tools you need to make sure we accomplish your goals. So the famous lawyer answer is, it depends. We like to not commit to an answer because there's so many other different pieces of that question that we need answers to before we can give you some firm advice. So with that, one thing I'll encourage you to do, if you haven't already, is on our website, emilytaylorlaw.com. We've got a page that is digital resources, and there you can find links to several different guides that we have. But specifically, one of the things we have is a workbook for estate planning in Arizona. It's free. I encourage you to go ahead and check it out, download the workbook, and go ahead and see if that might be helpful as we go through this planning process for yourself. You don't have to have it today for this presentation to be helpful, but I do think moving forward, you might find it jog some questions, allows you to kind of outline your goals and questions so you can be better prepared for starting the planning process. So with that, within that workbook, I've shared a couple pages here on this screen because it helps us kind of, again, decide what are we really doing, or what are we trying to accomplish by creating this estate plan. And so every individual has different things that are top of mind for themselves. And when we think through what our goals are, some common ones are to hopefully stay out of court. In general, court is daunting and expensive. And if we can avoid it, let's try. A lot of people want to have the goal and concern that they want to simplify the process should something happen to them. So that's going to be a big part of your goals potentially. A lot of times, families I work with have children or grandchildren or other potential people who are involved who might have resources such as Social Security or Medicaid. So sometimes that's a concern. But you can see there's about 12 or 13 different prompts here that allow you to kind of reframe, okay, let's go back to the beginning. I think I need a will. I think I need a trust. I understand an estate plan is important, but why do you, or why does your family personally want to make sure we have these elements in place? What are we trying to plan for? So if you download that workbook through our website, it's free. It'll allow you to kind of think through, okay, what are my highest priorities? And then that way, when you come in to see me or somebody else, you'll have a good sense of what you're trying to accomplish. Now on here, I also just want to quickly kind of go through. Sometimes we're planning for a generation up, our parents. We might be supporting them in some ways. Sometimes we have adult children who are responsible and can be involved and make decisions and can manage their own money, but we actually want to create opportunity to plan their inheritance to be protected from creditors or liability or divorce. Sometimes those son and daughter-in-laws, we want to make sure they don't get their hands on anything as best we can. A lot of times we want to plan for your personal health care wishes. We want to be clear about what that looks like. End of life planning, naming a guardian for our minor children, your pets. That's one of my favorite topics. If you've been to our website, you'll see Athena, my dog, jokingly plays a role at the firm. But pets are very important to us. So how can we plan for them? And then a lot of times we want to think about how do we want to be charitable or philanthropic through our plan for our churches and charities we care about. So this gives us a way to start to kind of prioritize what's our highest priority and oh yeah, what else matters? And what else do we want to be mindful of as we go through the estate planning process? And then sometimes you've got very specific goals or plans. Sometimes we have a business where we need to plan the succession of our business through our estate plan, or sometimes we have family conflict we want to avoid. So this gives us a way to start thinking so that as you meet with a professional to firmly plan your estate, that we can kind of think through what we're learning about today and hopefully give you some guidance there. So I'd encourage you to spend a little bit of time doing that. It's always helpful. So with that, if we're going to start, the place to start, and I think most adults, is with our health. We think about and make healthcare decisions for ourselves all the time. Probably should have thought a little bit more about what I ate for lunch today in terms of how it impacted my health. But big picture wise, we make a lot of decisions about the doctors we see, the treatments we receive, the medications we take. And so planning for a time when we may not be able to make our own healthcare decisions or potentially communicate them, whether it's because we're under anesthesia during a major procedure or if it's a long-term change in our cognitive capacity. One of the elements of estate planning is our healthcare directives, oftentimes called advanced directives. And so we have a lot of these tools in Arizona, and we want to make sure they're in place. If we're an adult and we can sign these documents and understand the consequences, we want to say, here's who can make my decisions if I can't make or communicate them in the future. Primarily, we're going to do this through a vehicle called a healthcare power of attorney. Many of you have probably gone in for a procedure and the hospital administration or your support team will say, do you have a healthcare power of attorney or do you have a living will? It's on their checklist. Unfortunately, they don't do a great job of helping you get one if you say no, but you do want to have one in place because they're important and we never know when there might be a period of time where you can't make your own wishes. So that healthcare power of attorney in Arizona is not only going to name the person or persons or professionals who will step in and make our healthcare decision for us, but it also lets us answer some advanced questions about, do we want to be an organ donor? Do we want to make a voluntary autopsy? Do we want to be buried or cremated or whatever's cheapest or most environmentally friendly? That healthcare power of attorney is a really important tool. And by having this in place and by having a team nominated, what we hope to avoid is a guardianship process. And a guardianship is when we have a sudden health crisis or inability to communicate our personal decisions related to our health and living arrangements. And we don't have this documentation in place. And therefore, the court has to get involved to appoint someone to be able to make these decisions on your behalf. So pretty simple paperwork to get put in place to get the right team in line to avoid a headache at the court level. Now in Arizona, we also have mental health care powers of attorney. This is commonly for specific inpatient psychiatric care. If you've been lucky to not need any mental health services as an adult, that's great. I still encourage you to consider signing one of these. We never know when this might come up. And if you have a team in your life of persons or professionals that you think could make good decisions for you, a lot of times we want to, again, grant them this authority if you can't make your own decisions. And again, in that case, we're avoiding court-ordered treatment or an emergency guardianship. So really important to be a part of your element of your healthcare directives if you're here in Arizona. Now, a living will, and you're going to hear a lot of terms used many different ways, but this idea of will, there's not one, there's several, but we've got primarily a living will and a last will. Your living will is what document controls during your health inability to communicate and as a part of your advanced directives. Your living will is your opportunity to share your goals and philosophies about care towards the end of life. And so a lot of us think about catastrophic injury or illness that results in life prolonging procedures, kind of that ICU setting that we see on some of the medical dramas on TV. But your living will is your opportunity to share your goals related to what is a quality of life that you want if you're on life prolonging procedures. When should family or friends make these decisions for you? It can direct artificial food and hydration. It can direct treatment that you would want or not want during a period of advanced Alzheimer's or dementia. It can include encouraging your agents to consult with palliative care and hospice care and pain management and those types of things. So a living will is really, really important to give the team you're putting in place an idea of what your goals and concerns are so that they can hopefully effectuate your wishes without being put in that really terrible spot of having to make big decisions like that without getting your input and guidance. So a really important part of your healthcare directive. Now, of course, with that, we also just want to make sure we've got HIPAA waivers so that the right people can get the right information when the time is right. And then a lot of times we also hear these terms like DNR, a do not resuscitate, or a POLST, a physician's order for life-sustaining treatment. But these documents are different. Where our living will is giving guidance to our team who's making our decisions, our DNR and our POLST are directive towards healthcare providers and first responders. So in those documents, they do need to be reviewed by your physician with you and signed off by a medical professional. They're very powerful, and so we really want to understand the consequences of having them in place. But unless you're already on hospice care or perhaps very advanced in age, you probably don't have a DNR, even though this is a term we hear a lot in pop culture. So all of these healthcare directives are really important. They hopefully will keep us out of a guardianship or emergency guardianship procedure. One of the important things we want to make sure we've thought through is who are the right people or professionals to be our advocates. Advocating for one's healthcare and personal wishes sometimes requires a pretty strong and organized spirit in the sense that they've got to keep a lot of things under control. And so something to spend time thinking about. And it's an often overlooked part of the estate planning process. So highly encourage you to get this in place, to think about it. Now, we are very lucky in Arizona. We have healthcare directives and advanced directives available for free through our Attorney General's website. So if nothing else, if you don't take any other action based on our conversation today, I implore you to download these and at least get the very basics in place. The forms aren't perfect, but they do allow you to get a lot of this critical information in place and can be really helpful. So make sure you read all the instructions on how to complete them and the like. But if nothing else, I'd love for you to have that at least as a basic starting point. Now, as we move on and we start to think about what else would we need if we were here on Earth, but for some reason unable to act. So like healthcare directives, we also have financial directives related to our inability to make or communicate financial decisions in the future. Now, where with healthcare, we were trying to avoid a process called guardianship. In Arizona, we have a process called conservatorship. And so our goal is to use tools such as financial powers of attorney, co-ownership, and signers on accounts to hopefully avoid the need for conservatorship. So for the court to have to get involved again to remove your rights to make financial decisions and grant it to somebody else. So always you're going to want to have a pretty broad and powerful financial power of attorney to name persons or professionals to make your financial decisions when you can't. Some people think, oh, I've got, my spouse as a co-owner, or I've added my daughter as a signer, and that's going to cover everything. That may be true as it relates to a very specific financial institution or a very specific account. But broadly, if you're incapacitated, there is a whole slew of things that you've never thought of that need to be handled. Things like signing tax returns, things like changing your mailing address, managing your tangible property. So we need a broad and powerful financial power of attorney in place if you've got the right team to nominate. That financial power of attorney typically is kind of one of two ways. One, it could be effective immediately. So upon signature, witness and notary, you've granted authority to someone to make these decisions. That's kind of nice because it prevents the barriers, and it's great if you're in a, maybe you're married or in a long-term committed relationship, or if you have a child who's very close and trustworthy. But sometimes we want to make these powers of attorney not effective immediately, and we want them to be what we'd call springing, that they start to work upon meeting a certain criteria or threshold. Often that is a medical professional putting in writing that you can't make or communicate your financial decisions any longer, and so the doctor signs off that you are incapacitated. Sometimes we can have two doctors. Sometimes we can require other thresholds. That's something to talk to your attorney about, what you want that to look like. But financial power of attorney, very, very important, that if you're alive, but for some reason can't get to the bank, can't sign your bills, can't manage your financial affairs, that your financial power of attorney allows your family or friends or professionals to avoid that conservatorship process. Now, I will just kind of put an asterisk on the guardianship and conservatorship piece. I work with a lot of families who have young adults in their family who aren't in a position to ever be able to sign a power of attorney. And so we involve the court for guardianship in that case as well. This is different. In this case, we're thinking about an opportunity to plan because an individual who does have capacity can sign the appropriate documentation. In thinking through this, what we need to understand, though, is when we sign healthcare directives and financial directives, it in no way limits our ability to make decisions or take action. So we're not giving away any of our power, which is good and bad when we have a young adult who perhaps shouldn't have the power. So just a note there. And the other thing I'll mention is just understanding how badly you want to avoid guardianship and conservatorship is really, when we start to talk about probate, understanding who's entitled to be a part of that process. Who's going to get paid as a result of that process? How long is it going to go on? So I don't think I need to spend all day telling you that, but these documents are a much lower threshold and easier ability to get the right team in place and make sure you've got who you want involved in your health and finances if you can't make or communicate your own decisions. So now with that, we're going to kind of leave this idea that you're alive but incapacitated or unable to make decisions and move on to what happens when you pass away. And in that, we want to think about first and foremost a couple of things. So one of the things I always remind folks is it's really important not only to have these legal tools in place, but to really understand what that means in your personal life. And so part of the process of working with an attorney and going through the estate planning process is to really understand and gather a true representation of what you have. Now, when we say estates, some people presume, oh, I need $1 million to have an estate. No, that's not true. Any amount of assets and resources you might have is important to understand and document. We want to know, what is the asset? How is it owned? And do you have any beneficiary designations? Those things are really important because the thing we need to remember is when we think about what's going to happen to our assets and who has control or use of them, both at incapacity and at death, those things such as ownership is going to control. So if you own an asset with an ex-spouse or if you own an asset with your sister, that we need to understand might supersede and control above and beyond the plan you're putting in place. Now, beneficiary designations can be great because they are what we call non-probate transfers. And in that sense, a non-probate transfer allows us to transition an asset without having court involvement. Usually it allows for an exchange of the asset based on some simple paperwork and a death certificate, depends on the financial institution. But we need to understand that that's going to control and supersede what might be in our will or our trust. So anytime we think about estate planning, when it comes to our assets, which is a part of estate planning, not all of it as we're learning, but a part of it, we need to understand that that's going to control and supersede. So if you are married, for example, you might have a home that's community property with rights of survivorship. You might have joint accounts. You might have your spouse named as a beneficiary. If you're not married, you still might own an asset with a sibling. You might have a beneficiary named of your best friend from 20 years ago. All these things are going to be really important to understand so that as we start to talk about and look at wills and trusts, we understand how much control that's going to have over our assets. So a big part of estate planning is really understanding that we can put these tools in place, but we need to understand how the tools are going to work and what's going to control. So a good starting point is to really document, okay, what do I have? How do I own it? And do I have current beneficiaries right now? Now we're kind of limited in that opportunity. So when we have co-ownership and beneficiary designations, often we lose the ability to grant any specific rights or level of control over those assets. And so a lot of times we think about, well, can I just put a beneficiary on everything? Maybe. If that meets your goals that we talked about earlier, maybe you have one adult child and one adult grandchild, and you've got a succession, and you can just say, if I die, then it goes to the adult child who has no liability concerns or isn't able to, is able to manage those assets. And then we can use beneficiaries. But a lot of times that's not how our family works. We don't just have one person we want to inherit everything outright, and that's appropriate. So anytime we start to think about bigger picture, maybe we want to share assets amongst a group of people, like our children, or maybe we want to provide for charities or our grandchildren who are still too young to manage those assets. Then we start to think about how can we create a tool that lets us define who we want to be in charge and what exactly they're supposed to do with those assets. So the first way we look at doing that is creating a last will and testament, not a living will like we talked about earlier, but a last will. I think we're familiar with this term because we hear about it in novels we read and movies we watch. The idea of a will is a expression of who we want to administer our estate, what we'd call in Arizona our personal representative. We are nominating them in a will. And then we also want to say, where's everything going to go? So when I die, where do my assets go? Now, what we need to understand is that if we have an asset that has a beneficiary, that beneficiary means that that's going to take precedence. And so if I pass away and my retirement account says my best friend from 20 years ago is the heir, then they're going to accept that asset, and that controls. Now my kids might be mad because what do you mean they're the person who's going to inherit? We are your loved ones that you provided for in your will. No, the beneficiary designation is going to control. So wills are really important, but we again have to understand the hierarchy of what's going to control. And so wills do govern assets of our estate. Now that's important to understand, because assets of our estate are assets that don't have a co-owner with rights of survivorship, don't have a beneficiary, and aren't in a trust. So you can start to see how important it is to really understand what you have, who owns it, who the beneficiaries are, so we can understand which legal tool we want to or need to put in place, or go back and change ownership and beneficiaries to match our intentions. Now, wills are great because, again, we get to decide who's going to be in charge. We get to nominate a guardian. So if we do have a minor child, so somebody under the age of 18, or a person that we are legal guardian of that's an adult, we get to nominate our successor guardians in that last will and testament. And then we get to direct the distribution of our estate assets. Now, the limitation is a will does not in and of itself grant that authority to a personal representative. In order for the person we've nominated or professional that we've nominated as personal representative to have any authority, we've got probate. And so probate's the naughty word of the hour. We get postcards in the mail that say, warning, you might go to probate, join us for a lobster dinner, that kind of thing. But probate, what is it? So probate and understanding probate is really helpful, again, to really put together our personal puzzle. Probate is the process that the courts appoint a personal representative, what we commonly think of as executor, to administer our estate. And then they define who's going to inherit, whether that's based on a will or if you die without a will. And then the court is going to supervise and direct the actions of the personal representative. So it sets up things like requiring notice to creditors, publishing notification in a newspaper. It requires certain levels of notice. So that is what we mean when we say probate. It's that formal process where the court gets involved in administering your estate, either according to the wishes you've put in a will, or if you've died without a will, administering it according to what we call intestate laws, the laws of who inherits based on our statutes. So here's kind of 5 common negatives of probate. One is it's time consuming. So we talked at the start about generally a goal of wanting to make it easy for our team and to avoid the court. And that's because time consuming. One, we got to find a lawyer usually because it's hard to do on your own. Doesn't mean you can't, but it's hard to do on your own. 2, we've got to make sure we get all the paperwork prepared, get everything to the court. Sometimes we need a hearing in front of a judge and we have to wait for that. Sometimes we can get appointed informally and it still takes some time, but it delays the opportunity for the team we want to be in place to get access to our assets and start administering it. It's also time consuming because it does have a creditor's period, for example, where the estate is required to be open for no less than 4 months for creditors to potentially make a claim. Commonly, 4 months is a very, very short estimate of how long it usually takes. I would say on average, it's about a year, but it can have a whole bunch of different circumstances depending on timing for filing taxes, how difficult it is to find and locate the heirs. All sorts of things can extend the timeline of that probate, really slowing things down. It can be costly. So it can be costly if lawyers get involved, legal fees for doing things like opening the probate itself, filing fee with the court, the publication fee, those kind of things. Some states have some crazy rules about how lawyers get paid, so it can be really expensive, but it's going to vary, and we don't know what that's going to look like. Now, of course, too, if people kind of come out of the woodwork or you have heirs who aren't getting along, it might get really expensive if people are fighting. It's also public, so a probate is not a secret or private process. It's public and it makes certain information available to the public. That's why when some celebrities die, we get to read their wills, we get to know what they had, things like that. So we just need to be mindful of what that looks like for you and whether that's a problem or not. And then there's a certain sense of loss of control, right? We've got a lot of things that are governed by our state statutes that we may not understand or know what they say. And judges may have input, lawyers may have input, all sorts of things. And it opens a door for potential conflict. Now, it's not to say conflict can't happen in any circumstance, because it absolutely can. But it creates an open door for people who may be entitled to notice to be involved in a process that we didn't really want them involved in. So if I write a will and I say I have 3 children, but I'm estranged from one of them and I intentionally do not provide for them, and then that will has to go to probate, I do still potentially have to give notice to that child. So they're going to read this document that says I didn't provide for them. And then if they say, well, I need to go see a lawyer because X, Y, and Z, it opens kind of that can of worms where they've been invited to the conversation, even though your intention was to keep them out. So just something to be mindful of. These are very general, big things, and sometimes they play a bigger or smaller role in deciding how you proceed with your estate plan. But if we go back to kind of big picture, we need to know our assets. We need to know the owners, the beneficiaries. We need to know if that's going to work and what doesn't have an owner or beneficiary. Pathway number 1 is using intentional beneficiary designations to avoid probate. Pathway number 2 is saying nope. We need to put in place a structure. So we need to have somebody administer the estate. We need to have some trust for our grandchildren created in our estate plan, things like that. If we use a will, that's great. The will is going to control our estate assets. And we understand that when it comes time to administer the estate, we're going to need the process of a probate. Now, if I kind of covered this, but it's a big caution. Certain people must receive notice, and it's defined by our statutes, and it depends on who's involved in your life. And this is whether or not they're named in the will. And so sometimes estranged family members, this can be a big problem. So just be mindful of that if you're signing a will and you want to make sure that maybe your sibling doesn't ever know what you had or what goes on, and you don't want them to have a say. Probate may not be the way you want them to go. And so it's out of our hands. So just something to be intentional about. So how can we avoid probate? Joint tenancy, sometimes that might work. Beneficiary designations, sometimes that works, kind of like in our example where we've got adults who we're not concerned about and we want that to control. Pay on death, transfer on death, POD, TOD. There's a lot of kind of terminology that different financial institutions use related to this concept of a named beneficiary. And then trusts. And so trusts are terms, again, that we've heard probably a lot about. And you may say, well, I noticed my neighbors, when I when I get nosy and I look up my neighbor's deeds, do they have a trust? I don't know. But trusts are things that you hear about. And sometimes we have stereotypes and ideas of what they might be. But realistically, a lot of times what trusts are tools that are going to allow us to partially to avoid probate if they're fully funded. So there are 5 things I want to go back over related to relying on beneficiary designations. Again, sometimes that can be a great solution for what we're looking to, but sometimes we're not good with beneficiaries having a backup plan. So again, if I named my adult child, but then something tragic happens and my child passes before I do, and I don't have an opportunity to put a new beneficiary and I don't have a contingent, then we have an asset that's now subject to our estate. Sometimes beneficiary designations kind of undermine your estate plan. So we need to understand again how they fit into the big picture overall plan. There's no protection for beneficiaries in the sense that the asset passes directly with no oversight. And so if we have a child who potentially has Social Security or Medicaid benefits, they have a disability of some type, they are vulnerable, then we leave this asset directly in their hands. It exposes it to their risks, their liabilities. So it's not suitable for all beneficiaries. And again, it may create conflict. So sometimes I'll hear, oh, mom took me to the bank because she wanted to make sure I could sign checks and the bank put me on as a co-owner. It wasn't that nice of them. Well, boy, you think that's nice of them, but when mom passes and that asset's yours, your siblings may not feel the same way. So convenience may lead to family conflict, and making sure things are intentional. So just some downsides. No one plan is perfect, I promise. But just understanding what these potentials are allow us to kind of put things together. So when we look at trusts, there are probably hundreds of types of trusts. That being said, there are trusts that we're going to talk about today primarily are going to be what we call revocable living trusts. So trusts are operation manuals. They're a tool we put in place that allows us to write the rules of how we want trust assets to be governed. It allows us to put a team in place, those trustees, successor trustees, the idea again of who's going to be an executor, who's going to step in. We can also create a system of advisors or trust protectors. There's different roles we can include. And then the trust is also going to direct the administration of these assets, but we get to direct the administration now while we're alive. What happens when we're incapacitated, what happens when we die, and cover contingencies. So trusts, oftentimes, they're legal documents, but they're going to be thicker. They're going to be a lot more pages and a lot more legalese, if you will, than some of the other documents you see, because we've got to cover a broader span of time. Now, trusts as a primary probate avoidance tool work well to avoid that court process we've been talking about, so long as we close the loop. We've got to go back to that number one pathway. And when we set up a trust, I set up the Emily Taylor Living Trust, I then have to make sure that that trust document governs my assets. And it doesn't by default. It doesn't do anything automatically. It's just paper. I have to go back and I have to retitle my home. So I have to deed my home from myself as an individual to myself as trustee of my trust. I need to go back and look at the ownership of my other accounts, look at the beneficiary designations on my accounts, look at the titles to my cars and boats and I don't know what else people might have, timeshares, all sorts of things. We need to make sure that we really go back to, if we're going to spend the time and energy to be intentional about deciding who's going to be in charge, making it easy for them to step in, hoping for them to avoid probate, putting this plan together, we've got to finish the job by making sure that our assets are appropriately titled and our beneficiary designations are the way they're supposed to be. And this is a huge step that a lot of people miss, especially if they're doing do-it-yourself trusts on the internet. They're not great about allowing or educating families how to then go ahead and set up this last piece. And so in concept, the trust is easy. We're making the same decisions as a will. We're putting it on paper. We're signing it with witnesses and notaries and meeting all these legal standards. But the reality is that if we want them to work the way we need them to work, we really need to understand the big picture. So I don't think I can overemphasize that enough. I've said it a lot, but hopefully that helps. Now, to be fair, I said negatives of probate. I said negatives of beneficiaries. I better say negatives of trust too, otherwise that wouldn't be fair. So some of the downsides of trust are there can be upfront costs because you're spending more time with an attorney, not only defining further what your wishes are, but also spending time making sure the assets are the way they're supposed to be. Legal fees up front can be higher. Now, probably not higher than probate, I would say, but they can be higher to work through that process. And so sometimes if you're looking for an easy or cheap plan, it's cheaper to put a will in place because that's a quicker process than it might be to set up a trust and fund the trust. So just something to be aware of. You want to understand the professional you're working with, what they're going to charge you and what it's going to look like. And that's really important part. So that can be a negative or a downside if you don't see value in it. Requires ongoing maintenance. Now, a lot of people say, does that mean I'm going to have to come see you and pay you all the time? Well, you might if you want to change the rules in your trust. I definitely would encourage you to work with your drafting attorney to update the terms of your trust document when that's happening. But if you've done a thoughtful job, the trust should be good for a period of years, potentially decades. It depends a lot on your life, but you don't need to have an ongoing cost or maintenance related to that. But what you need to be mindful of is that as you're opening new accounts, buying and selling properties, working with your financial advisor, that you're keeping up with keeping the trust funded, that your assets are titled the right way, that your beneficiary designations are correct. And so there is a maintenance, and that is a downside to making sure that the whole plan, when you've done all this hard work to make it work the way you're supposed to, that it stays working the way you want it to. And that is, of course, number 3, it must be properly funded. If a week before I die, I bought a farm and boy, I forgot to tell the title company I wanted it put in my trust. And so they closed on the property and now it's just in Emily Taylor's name. Well, shoot, I've got an asset that doesn't have a co-owner, doesn't have a beneficiary, and is not in my trust. I'm going to probate, even if I have that trust document. So you've got to make sure you keep up with all those things. And that's the ongoing maintenance that is required of you as the keeper of the trust. It doesn't automatically protect assets. So one of the big myths, I think, is that all trusts protect assets from creditors, liabilities, divorce, all sorts of things. That's not true, because if you think about it, it would go against public policy if it was very easy for you to just say, I can do all sorts of bad things and you can't touch my stuff. So revocable living trusts do not offer much in way of creditor and liability protection. A lot of times we're using LLCs or we're using insurance. And there are fancy types of trusts in other states and other places that you may want to look at using if that's really your ultimate goal. But most of the time we're going to look at using things like insurance and limited liability companies to provide the protection we're looking for. But I think it's still a myth. Now, with that said, we can offer some of that protection to the next generation. So some of your beneficiaries can benefit through the trust for protection in those areas. And so all of this just kind of proves that things you may have heard on TV or seen, in your friends' circumstances, trust can be misunderstood and misused. And so you really need to understand what they can do and what they can't do, and what the value is, and how that fits in with your goals. So really important in that way. What are 5 benefits to using a trust? If it's properly funded, it avoids probate. It's kind of nice. It means your successor trustee can step in based on the rules you wrote. So maybe again, it's that statement of incapacity from a doctor, or if you die immediately. It maintains privacy. So again, the trust administration, you get to define the information that people that you've named can get and things like that. But generally, it's much more private. It's not a public proceeding. It provides that control over asset distribution. So you can say, I've got 3 kids. My oldest is receiving Medicaid and Social Security, so their interest needs to go into special needs trust. My middle one's in jail, so we need to protect it from their creditors and make sure they don't get access to it. And then my youngest is on their 3rd marriage, and we want to make sure the 4th wife doesn't get it. Whatever your circumstances are, we can provide those different types of protection within your trust, and can be really intentional about it. So you get to provide some control over asset distribution. It again can protect the beneficiaries in some of those ways, and it also prepares for that incapacity. So because it covers both periods of incapacity as well as at death, it gives you that structure to make sure you've got the right team in place. Now, just because you have a trust doesn't mean you don't need a financial power of attorney. You still do, because you're still going to have assets and decisions that take place outside of your trust. And you still want a will. So even if we have a trust, you're commonly going to have what we call a pour over will. And that is the catch-all backup plan, just in case you went out and bought that farm, just to make sure that ultimately that asset does end up in the trust. But even that pour over will would have to go through the probate process. So there's a lot of other types of trusts we haven't talked about today. There are special needs trusts. I've got entire webinars on that. They're recorded. They're on our YouTube channel if you want to watch and learn about those. We didn't talk a lot about minors trusts. So again, if you've got children, grandchildren, other littles that you want to provide for, and perhaps they shouldn't be supervised by the court until they're 18, and then everything lands on their lap on their 18th birthday, we can set up a structure where we can kind of create a system where that young adult or a young child maybe gets access over time. Maybe we say they become trustee of their own trust at a certain age. We can plan for minors legally, as well as young adults who need a little more time to understand how to use and manage the inheritance they might receive from you. Now, there are irrevocable trusts you can't change, and you might do that for asset protection or Medicaid or other tax planning rules. There's many different types of trusts, but they're not as common as what we've talked about today, that revocable living trust for purposes of doing all the things we talked about. So will versus trust, did I answer it for you? I don't know. And that is because what we always need to go back to is what works for you. What are the nature of the assets you have? Who are you providing for? What are you hoping to accomplish? So that's your homework, is to hopefully download that workbook, kind of think and spend some time thinking about your circumstances. You've probably, if you've made it this far, you've already thought of a million things you do or do not want from your estate plan. I think when you're thinking through the 2 options, do you want to avoid probate? Some people say I'm gone, and frankly, it's a good oversight process. I don't have a problem with probate. Great, that's fine. One thing you want to think about is how complex is your family or financial situation. If I've got $100,000 in a bank account and that's really my only asset, and I've got a beneficiary, that's going to be pretty straightforward. On the other hand, if I have a family business and a cabin and 20 bank accounts, it gets a little bit more complicated. So we got to think about that. Do you have young children or family members who might have special needs or disability benefits? That's going to complicate things, and we want to think about that. Are you concerned about privacy? Some people are, some people aren't. And are you willing to do some of the upfront work? So, I often hear over the years, I want a simple plan. When you say that, do you want simple planning documents right now, leaving the work to the people who have to step in later? Or do you want to have a plan that makes it simple for other people? And so really understanding what your goals are helps you think about what that looks like. Now, another huge part of this, which we haven't spent a lot of time on, but what is the value of working with a legal professional is really being intentional about the who of all of this. Who's going to be named in your healthcare documents? Who's going to be your financial decision maker? They don't have to be the same people, or even maybe you want professionals on one side and family and friends on the other. Who are your beneficiaries going to be? Did you think about, oh yeah, that charity I always provide for, I'd love to make a gift to them. Are you thinking down the line of grandchildren, great grandchildren, and the like? If you need to nominate a guardian for minor children or adults with incapacity, thinking through what that looks like, who has the capacity to take that on, and who can you ask to be nominated in that role? And then all of the backups. So there's a lot to think about. And what you'll find in the workbook too is some guides for thinking through what are you looking for when you're thinking about these different groups. Some people have a bench that's 20 people deep, and we get to find the perfect people and the backup plans and put it all together. Some people have one or two trusted friends or family, and they're going to get all the jobs. But how do we make it so that they're not shouldering too much of that? You'll find, like I said, some guides I don't have on the screen related to how to look for that, but specifically, again, brainstorming, thinking about who am I planning for and what might my team look like. And then in the end, of course, just thinking about legacy, peace of mind, relationships. What else can you do with your estate plan? So you might want to plan for your pet. We have some pet planning guides that are free on our website. You can download how to take care of, my Athena, for example. Who's going to feed her? What does she like to do on her walks? Things like that. But your relationships, if you have a relationship or a strained relationship, perhaps with a child, and you want to communicate that, you might have a letter that kind of complements your estate plan, all sorts of things. And so just really thinking about what's important to you and what that might look like. So what do you need? The right tools and the right team. And that's the hard part. I can't answer that for you, what those tools and team are going to be. But hopefully this has given you some guidance that you need to understand what's right for you and putting that team in place. And it's really personal to you. So there is no such thing as one size fits all. If you've got X number of dollars, this is the right plan, nothing like that. I mentioned it a couple of times, and in the beginning, there's several resources available for download. So just take a look at some of that, go to our website, explore what's available, and hopefully those resources can help you think through these things. And then, of course, you're always welcome to schedule an appointment with me. I'm going to go this way and say thank you real quick. I am going to take questions if you're here live. Feel free to put those into the chat and we can talk about them, but I'm going to stop the recording before then. But I'll just say thank you. If you're in Arizona and you'd like to work together, you can schedule a consultation through our website. You can also call the office, but we'd be happy to work with you. We love working with motivated clients. And so, anytime you're interested, please reach out and schedule with us. If you decide to work with somebody else, please make sure it's somebody that you've got good communication with, that you understand what you're doing, and that they're sharing with you how you can not only put the plan in place, but also make sure we've got good decisions all around.